Hey guys, Marilyn Manson has filed his opposition to Wood and Gore's motions to strike parts of his lawsuit against them under California's anti-SLAPP law. So if they're successful, large parts of Manson's lawsuit would be struck and be out of contention. Obviously, he opposes that. We'll go over what his arguments are. It's largely a story of women being dragooned into making allegations against him. So gigantic props to Manson's law firm for shoehorning in an appropriate use of the word dragoon in their arguments. I like that. That's a cool word, dragooned. Were they really dragoon? Boy, that sounds terrible. How could you dragoon somebody? What kind of monster dragoon somebody? So that's his story. Well, let's get into it a little bit. So they filed the motions to strike, and then he filed motions asking for discovery. Remember that? He wanted to take some limited depositions to bolster some of the points that he was making to say, here's some more evidence why these things shouldn't be struck. The judge issued an order in that, denying most of the discovery, but allowing a limited deposition of Illma Gore. And in that order, I feel like the judge tipped her hand to her thinking on some of these things. So I'll bring that up where appropriate. So what's the point of his opposition? The point of it is to convince the judge to not strike the parts of the complaint that the defendants are asking to have knocked out. The other thing is to create an argument record for appeal, because this probably goes up on appeal. So you'll see some arguments that the court may have already indicated skepticism to. There's no reason for him to abandon those now. He should keep those on the record. So what I'll do is I'll look at the primary things that we're asking to strike. I'll break it down to what's he got new here. I'll show what the judge was skeptical about, and we'll look at what already existed and what did he bring new to the table here that might move the needle to convince the judge. So if the judge said, for example, this isn't extreme and outrageous, did he bring a new legal argument to say, no, judge, we all missed a case. It actually is extreme and outrageous under so-and-so versus so-and-so. Or does he bring a new affidavit or declaration in to say, well, maybe under the prior record that was sketchy, but look at this, it's very clear now. How does he move the needle? Does he move the needle? It's got a lot of smoke in these documents, a lot of smoke. Is there much of a fire? That's what we'll look at. It's just those limited things to examine whether he's moved the needle. So remember, it's not about really, although to some degree I guess it is about publicity, but from a legal perspective, it's not about convincing you or me. It's about convincing the judge. So when we assess Manson's arguments and how he's changed those or upgraded those, we have to put that through the filter of imagining what this judge will do. And you can do that through, well, how would any judge decide on the law? But also this judge has already issued an order. So she's put her thinking out there a little bit, and that helps a little bit. But still, we're limited in that degree because we're trying to imagine how someone else will view this, not just how we view it. And you can't let your own feelings color that, or you'll think the judge is corrupt and how could they think that? You have to imagine it through their lens. Another complicating factor is some of the evidence is now confidential and you don't know what it is. The deposition of Illma Gore took place, but all of that is redacted and under seal, right? You can't look at it. You don't know what she said. So if and when it's quoted in the arguments, you don't know whether it really helps Manson or whether it hurts him. It's a slam dunk either way. Who knows? There could be other things that are confidential as well. So now we have some holes in our analysis just from facts going up to this judge who we're trying to imagine how she'll think. She's going to also have facts that we don't even know what they are. So there are some limits in predictive capability there beyond the normal ones. Now, if you want to really look into the facts and everything that was said, and because there are a lot of details in some of the filings that haven't been put out there before, and some of them are supportive of Manson's contentions, I think. Some of them you could also pick holes in the other direction. But I'm not going to get into things unless I think it's relevant directly to moving the needle on a motion to strike. Now, Colonel Kurtz has put a video out already starting to look into the details of some of the documents. And I think she's already indicated she doesn't want to just dwell on law nerdy kind of legal standards and things like that, but more the case as a whole and the facts behind it and how it looks overall. She's coming generally from a pro-Manson perspective, of course, but still, if you want some details, you can get it there. Also, you can look at the Manson cases. She runs a Twitter account, Instagram, and other things too, where she gives access to the documents in the case and sometimes some blurbs about it. And of course, she and another person run a podcast that goes over the cases in much greater detail. And they're coming, I think, too, obviously from the standpoint that these allegations against Manson are not warranted. So know that they're not trying to hide it, but they're an excellent resource for the documents in the case and their perspective on the case as well. Then finally, from a legal perspective, I know Legal Bites is planning, or she has said she's planning on doing a video on this, and I'm sure we'll cover this in greater detail than what I'm about to do. So when you see that, check it out and you'll get a comprehensive look, I'm sure, of what's going on to this, and she knows what she's talking about. I don't know if Andrea Burkhart's going to do a video on this or not, or any long form content about it, but she has been watching this. And if she does, she's fantastic at going inside the briefs, looking at the cases that are cited and how those cases evolved. So some excellent legal knowledge there as well. If those two people come out with stuff, be sure to check it out. Now let's get into it. Anybody heard anything about this FBI letter? Am I the first person telling you about that there was like an FBI letter involved in this case and maybe it's fake? Has anybody heard that? I don't know if it's important or not, but I'll just go ahead and cover it anyway. So Manson has put in his lawsuit this FBI letter, which I think is a central piece of evidence. Whether it's directly controlling on the elements of his causes of action or not is one thing, but it just really looks bad. The story he can tell about it looks really bad for Wood and Gore, because his story is they created a fake FBI letter. So they falsely put out there a letter that they say was created by law enforcement, and it wasn't, is Manson's contention. It's fake, and it was used in a custody dispute to move things in Wood's direction. So a false document purposefully created to help her there, and then also used against him. That's his story. Now, her counter argument to that in the motion to strike is, well, whether it's true or not, it is not the material factor. The material factor is I only used it in the custody litigation, and under the law, I have a privilege for that, whether it's true or false. And the judge accepted that premise in the discovery dispute, and I think is going to continue to do that. Now, Manson makes some arguments legally and then some factual arguments as well. And let's see what he says. So I feel like to win this for Manson's side, this is just my opinion and based on what the judge has said before, that in the discovery ruling, she said, quoted Wood's brief saying this couldn't have caused emotional distress and it couldn't have been intended to do that. It could only have done that through the letter's publication. And she says the letter was never published outside the custody litigation. And the judge notes Wood provides evidence in connection with her special motion to strike that she did not distribute the FBI letter outside the scope of her custody dispute with Mr. Bell. And discovery may not be obtained merely to test the opponent's declarations. So to me, the judge was on her side on that, saying, I know you're telling me that this was used against you, but you've got no evidence of that. Now, why you want it to be there, that's obvious, but show me that connection here. How was this used against you? So what did he say? He says first in his brief, well, hey, look, our claim is not based on the use in custody litigation. And I think that's true. They're basically saying, yeah, we told you that, but we're not depending on that. We just put it out there because that's a fact. It was used in the custody litigation, but we're not coming from that angle. Okay, that's a very solid argument. That's great there, because you're telling the judge, listen, respect on the litigation privilege, but that's not the basis for why we're trying to use the letter. And they say it doesn't get immunized once you file it in this custody litigation from every other use that it has, especially since they contend it was unlawful. And I think that's true too. I mean, just because you file it in a custody litigation doesn't give you the right to then go spread it around all over the world and say everything you want to say, and then say, but I filed it over here, so I get to do whatever I want, especially when it's what they say is unlawful, illegal content. So to me, that's compelling. So, and they say, impersonating a law enforcement officer, that's illegal. It's not protected kind of speech. So really shouldn't be an issue anyway. They should be able to contend it in the lawsuit. Nevertheless, the judge seemed to buy the argument in the discovery dispute that all of that being said, show me how it was used against you. Give me some evidence of that. So what has he got in his current brief, and what's old and what's new? So he goes back to the statement made to brighten Gore, she says, by Wood, that the letter was important to her work against Warner. Well, if that's true, she didn't say it was important to her work in the custody dispute. She said it's important to her work against Warner. There's an inference there that this letter is being used against Manson. That makes sense to me. However, that existed at the time that the judge wrote what she wrote. So you may want to be skeptical whether that's enough by itself to move the needle, because it's a fact that was already in the record prior to the discovery ruling. The copy of the letter was provided originally to the father, I think, had Gore's name on it, and that was deleted by Wood, and the letter was found on Gore's iPad. And Manson makes the case this couldn't have only been used in the custody dispute if Gore had it, because Gore's not in the custody dispute. She's outside the custody dispute. So it's already been distributed outside the custody dispute. It has seen the light of day. Now, to me, again, that makes sense. Why would Gore have this letter? Now, of course, she may be the one who created it. We don't know that for sure. But either way, this letter is not strictly inside the parameter of her attorney-client privilege and then also filed in the litigation. It is to a third party, Gore. So Manson's argument that other people outside this custody dispute who had no interest in it, they got the letter, starting with Gore. I like that. However, that also existed at the time the discovery ruling was made, and the judge seemed to think, yeah, but that's not out there, being used against you with these people. So what do you got there? And I think the idea is everybody thinks is, hey, this was used as a recruiting tool. That's Manson's angle, that this false letter was used as part of their way to dragoon these other women into making accusations against him. So did he bring some evidence? Did somebody show up and say, hey, I saw it and it was part of why I decided to speak against him? They do have in the declaration that they provided a comment that the leak in the Daily Mail story had a watermark from Wood's law firm, and that creates an implication that it must have been leaked from her side. But I don't think they carry that more than that. They don't make it any more clear than that. They don't really connect it to her. So I don't know that that's going to move the needle. But they do say for new stuff under the Meyer declaration, Michelle Meyer, that Gore was holding herself out to be involved with the letter. And in fact, it was Michelle Meyer's number that ended up on that letter, and she ended up with voicemails, right? People calling her, and then her telling Gore, hey, I'm getting these calls. What's up with this? Problem with that is the people who called her, one was the father of the child that was in the custody dispute. So that's not an anti-Manson situation. That's the custody dispute. Another person was Wood's own lawyer. So that's not necessarily anti-Manson, because they're not dragooning Wood's lawyer into testifying against Manson, right? And then one of Manson's attorneys, Burke, that law firm called too. And a matter of fact, Meyer said, I never saw the letter until 2022. So the dragooning by letter doesn't occur with Meyer, because she said she didn't even see it until this year. And I don't think the voicemails help the case that it was used against Manson, because of the people who left the voicemails. If Ashley Smithline had called Michelle Meyer and said, man, I'm calling you because I got your number from this letter. This is just terrible. I want to testify against somebody who would do the things like this. This letter is really helping me think that I should go against him. That just didn't happen, or at least it's not alleged in this declaration they have, and that's their new declaration. And sure, there's more descriptive stuff in Meyer's declaration about what Gore told her about things about Manson. It may not be true, the level of abuse against adults and minors, that sort of thing, as well as what Manson says are false allegations that there was an FBI investigation. Whether there was one or not, he says that's false, and he says that was put out there. And again, this is all inference to connect back to this letter. But remember, Meyer says in her declaration, I didn't see this letter until 2022. So the letter didn't dragoon her into anything. And I don't see in what he put out there evidence from somebody saying, I got this letter. Right now, there is more context for the letter. It makes it maybe even look worse in the overall narrative of things. I agree with that. I mean, Meyer talks about how her number was used and she's been traumatized by that. And she was basically taken advantage of by Wood and Gore, she feels like, I think. And so I get all of that. I absolutely get all that. But if the question is, how was this letter distributed and used to recruit against you? Where is the new evidence for that? Because it's not really Meyer, because she didn't see this letter till 2022. So what is it? Again, now I feel like Manson's argument that Gore had it, it does indicate it was used outside the custody context. Whether it's a lot or little, you can't say that it was only used in the custody context if someone else had it. She had it on her iPad, and then, taking the evidence in his favor, which is what you should do. Wood makes a comment to Brighton Gore, this is really important in my work against Manson. So you've got the letter in another person's possession and one of the defendants saying, I want to use this letter. It's important for me against Manson. I would have think that would be enough. Now, remember, the insight into the judge's thinking was just for purposes of whether Manson got discovery or not. Because I would have let him take discovery on that. I would have said, there's enough here that I think she should set for the deposition to answer questions on how did she distribute this letter? How did she get it? Who did she ever give it to? Because that's the whole question. I mean, what would that take? 45 minutes? But the judge didn't feel that way. That's why I feel like she's leaning to striking this unless she sees some evidence from Manson showing the connection of that letter, actual use of this letter against him outside the litigation context, then she may strike this. But she may not, right? I mean, that may have just been her position for discovery, and then she's going to be looser when it comes to the actual motion to strike. I don't know. But if I were betting, I would bet that her position was, I don't see the connection. I'm going to strike it unless you show it to me. And I still don't see you telling me, although there's a lot of smoke here, a lot of new details. The letter's terrible. It's absolutely terrible, taken as the evidence shows what you've given me. But you still didn't show me, even after that heads up, how this letter was used against you. Instead, you submitted a declaration saying, I didn't see this letter until 2022. So unless I'm missing something on the actual use of the letter, not how bad it is, because I concede all that, I think it looks bad for them on this point, even though, I would personally disagree. I'm trying to read what the judge will do based on what she did in discovery. Understanding that what she did in discovery may not be what she does now. And I'm trying to do it without knowing what the reply will be from the defendants, because they get to make their final reply, which is going to try and drag down Manson's arguments. And there were comments made about this that are redacted. They could sway my thinking, the judge's thinking, your thinking. We don't know what it says. So that's round one on the FBI letter. Your opinion could be different. I'd be interested in hearing your opinion, especially if it's not that, hey, this letter's really terrible, because I happen to agree with you there, but you missed this, dude. You missed this. This is how it was actually used against him. Not it probably was, but here's some evidence that it was used against him, because if I miss that, that certainly matters to this. If he shows it was used against him, I think that addresses the judge's concern. Now, the recruitment. Manson has said that the women were recruited, coordinated, and pressured. That's not the word conspiracy against him there, but that's really what he's trying to say there. Pressure's bad, right? I mean, pressure's bad. Pressure's not such a terrible word, though, is it? Coerced would be a good word. Coached would be a good word. Recruiting and coordinating, it didn't seem to sound that bad per se to the judge, because this is in the context of an intentional infliction of emotional distress. And in the Halloween video, I went over what it takes to make a claim like that. And experiencing emotional distress is just one aspect. And the defendant causing it is only one aspect. A big aspect is you have to show that the conduct that caused it wasn't just conduct that caused it, but it was conduct that was extreme and outrageous and outside the bounds of what should be tolerated in a civilized society. And that created a problem for the judge. In the discovery order, the judge had access to everything that Manson had filed with his complaint and the things that he filed to support his request for discovery. But the judge noted that in the messages that were quoted, that Gore said, there's no pressure to being involved in any way. And then the court found the court agrees with the defendants that the purported messages from Gore to McGaffigan and Balog are not so extreme as to exceed all bounds of that usually tolerated in a civilized community. And so she didn't order discovery on these things. So she has said that, look, I read this stuff, and that may have caused you emotional distress. It may have been the reason for it, but it doesn't meet the criteria of being so outrageous, because an intentional infliction of emotional distress is not a butthurt tort wherever you feel bad, you get to sue somebody. It requires a high level of conduct, in theory, on the defendant's part in the first place. Something really bad, outside the bounds tolerated in a civilized community. Now, my reading in California law, and I'm not a California lawyer, but I've read some of the cases, sometimes it just depends on when you land in court as to whether you cross that threshold or not. I cited a couple of cases that I thought were close to the line with Manson in the middle in the Halloween video for the element of emotional distress and whether you caused it or not. I think it just depends to some degree on when you get there, but it can't be just a normal sort of thing or even kind of bad thing. It's supposed to be a very bad thing that you did. And one of the things that Manson has said in his case, these women were pressured to lie. And in his brief here, he says dragooned, which that's what I like. But were they dragooned? What's the, because dragoon implies that there was a level of force there, that you coerced these people into doing this. You seriously pressured them into doing it. It's a fantastic word for a very high level of pressure. Yet the messages say there's no pressure to join in this. I don't think there's any evidence that someone didn't join it and was retaliated against or threatened in some way. Like, you don't have to join this. There's no pressure to join it. But if you don't, you're going to be killed. If you don't, we're going to drag you through the mud. If you don't, you're going to miss out on all opportunities to work in this industry again. Is there something like that? It seemed like the nature of the thing by Gore, as alleged by Manson, was saying really bad things about Manson and then telling these women, there are other women who had bad experiences with him. We're going to get together and talk about that. If you did too, join in with us. Talk if you want to. Don't talk if you don't want to. Be anonymous if you want to. Don't be anonymous if you don't want to. That those messages, this recruiting and the coordinating, the judge said, I'm sorry, that's just not outrageous as a matter of law. And the question is, did Manson move that needle in this opposition that he filed from where the judge had that position before? So all the the meeting stuff, that's old. And Manson saying that the allegations against him are false, that's old because it was already in his lawsuit. And the fake FBI stuff, that's all already in his lawsuit. So it's good stuff, but it's old stuff. It was there when the judge said, look, I don't find this to be outrageous as a matter of law. So what's new? Well, good news for Manson. He's quoting something redacted. Is that awesome? I don't know. You don't know. We can't even imagine what it is. Does it show, wait a minute, we weren't able to tell you this before because there wasn't any redacted things back then, so this is something new. Look at this. It could sway the opinion on this of anybody if they could see it or not. We don't know. It's redacted. Now, King does have in his amended or supplemental declaration, has more exhibits in it, some more messages that they got. And however, those messages say, they do reference the FBI investigation that Manson says was fake and other bad things about Manson. Again, I think, though, that was stuff that was already there before. But it says no pressure. So even these new messages say there's no pressure. How much real pressure is being applied if you're telling people no pressure and they don't come and nothing's happening to anybody? And I would suggest don't pollute in your mind the idea that they said bad things about Manson, some true or untrue or whatever, as equating to getting you angry enough that, well, the pressure is implied. You got to do better than that. What's the pressure? I mean, what's going on here? Well, why do they have to do it? How are they being dragooned? Now, I get the idea that they all come together and they talk and maybe they start remembering things that didn't happen because they're all going to be similar and stuff like that. That's part of what his allegation is. But in terms of the recruiting, right, and the pressuring and the coordinating, where is that? Where's the pressure to lie? Where's the pressure to lie? To say, hey, look, these are things that other women have said. What do you have to say? Is that pressuring somebody to lie, or is that you wanting to believe that because you think this was a conspiracy and they should be punished for it, which I respect that. But I am saying to you, the judge has already said, I don't find these messages outrageous. What I'm saying is, what's the needle mover here, especially when the new messages say no pressure? I don't think that looks good for this. I don't think that what they've shown suddenly turns it into outrageous conduct. The exception to that could be the fact that they've added more detail about the horrifying things that were said about Manson, whether they're true or untrue. He says they're untrue, and they're out there in a declaration that he submitted as evidence. So you take his side of it for this purpose of whether the lawsuit can go forward on it or not. And it's all terrible. And if it's untrue, as he says, I think it kind of is outrageous. That's my opinion. If you're rounding people up by lying about somebody and saying the very worst things that you can possibly say about them and creating a pool of people from a basket of lies, if I were sitting on the bench, I might let it go forward on that basis and let's find out a little more about this. But the judge said the messages you showed me were not extreme and outrageous. And that indicates to me you need to show me communications that are extreme and outrageous and pressured. You said that they were pressured to lie. Where is that? How are they pressured? Where's the pressure at when it says no pressure? I think that's a problem for him. In my opinion, it still remains a problem for him. Again, the judge could look at this hearing differently than the discovery hearing, but why say those things then and change your mind now unless there's something comes up that changes your mind? Then there is the groupie comments are also part of the intentional infliction of emotional distress claim and are contested for that purpose. And in the context of Woods contesting that, the judge said, well, I don't think there was really conspiracy allowed here or alleged here. So as to the comments themselves, I think that's staying in. The judge allowed discovery on Gore's intent when she was making these comments. They're terrible. They're straightforward against Manson. They were communicated to third parties. So see, other than outside the pressuring context, there is the aspect of what she did say about him that was false, that was terrible, that I think the judge is going to allow that to go forward. That's going to be allowed to be an element of this IIED claim. That's my opinion. And she allowed discovery for it. Is there going to be something come up from the defendants in a reply that makes that needle go back in the other direction? I doubt it. I doubt it because it's terrible. He's contended it's false. Other people have supported him with evidence. So I think that stays in there. The weakness the judge identified was, hey, the allegations of Wood being in a conspiracy for this in a substantive way that would allow her to be vicariously liable for Gore's statements. So if Wood didn't say it and Gore did, how do you make Wood liable for that? Well, one way is you say they were in a conspiracy together, and so it was a common scheme and purpose. And the judge found that the allegations were not, and I guess the way I read her order, they weren't good enough. There's not enough there to show that. Did that needle get moved? Otherwise, it may be struck there. What does Manson come up with that's new for this conspiracy? He says, well, Wood let it be in her movie. That's not really new, though, is it? We already knew about this documentary, and we knew that some of those accusations were contained in there, the groupie clip or whatever, and that was in there. Was it her movie? Thought it was HBO's movie? I don't know. That's a little bit of a leap there. She's not the video editor, I don't think. I could be wrong on that. But at any rate, I feel like that existed at the time the judge made her comments, that how you're showing conspiracy to me is not stacking up. What's new? Again, there's a piece of redacted information there, and that could swing this thing completely around because they were able to take a deposition of Gore, limited, but on this topic. And now they're quoting something redacted, and that could be enough to swing this and show this level of conspiracy here. They do say in the brief, Wood spoke with Gore and did not correct the misimpression that the groupie video involved illegal conduct with a minor and let it be used in the movie. But again, I feel like that's something that we knew before this opposition came out, that we knew before the judge issued her decision on discovery, saying, I don't see the elements of conspiracy here. Now, again, when I read the cases on conspiracy, it didn't seem like you had to really say a whole lot to have a conspiracy case against somebody, that if they were in this common plan, scheme, and purpose, and they know about it, and it's furthering the goal they both have, then you could potentially be vicariously liable. And Manson has made lots of allegations that they were in it together to get him. It's hard to divorce, to me, the fact that Gore would go out and make this statement about Manson, whether it's true or untrue, from the idea that they were both trying to work together to go against him, that's true, right? I mean, yeah, we knew about the documentary, and I guess the main thing about the documentary is not only did they dress alike and act alike, but they had the same mindset of what they thought the outcome should be against Manson. So whether it's a conspiracy that's bad or good, weren't they working together? It's hard to find Gore being an independent actor there, rogue away from what Wood's purpose was. I thought they were acting together. So again, if I were sitting on the bench, while I'm not taking Manson's side on the case, I probably would have seen the discovery a little differently, and maybe also the evidence in general. But I'm not the judge, right? The judge is the judge, and the judge does this for a living, and she's handled I don't know how many anti-SLAPP cases and has a feel for how they should go and how they're decided on appeal and that sort of thing. So you got to channel her, and she was very skeptical of this. Is there something new here that would decrease that skepticism? The argument made more clearly, new evidence. A final couple of other points that Manson had in his brief that I think are important is, hey, judge, even if you strike these things for purposes of our cause of action, in other words, the intentional infliction of emotional distress claim, say, even if you take it out of there and say it can't be a basis for that, you shouldn't strike the allegations generally in the complaint because they provide context and background for other causes of action, other supported causes of action that aren't based on protected speech. They're context for that. They show the whole landscape of this. And this was a question that was asked by the Manson cases in the podcast that they just did recently. So they saw this coming and said, hey, do you think if this gets struck from the cause of action, is it just gone? And in my opinion on that is yes. Now, I already told you the limits of my opinion, and they're particularly evident in a scenario where I don't do anti-SLAPP cases and haven't, or practice in California. But here's why I think that a couple of reasons. One is Manson did not put the FBI letter in the lawsuit as a background context, mentioning that it happened and then not have it in his cause of action. He had it as in the cause of action. He had that, and the pressuring to lie and the recruiting and coordinating were listed as elements in the cause of action. So if all you need to do to get out of an anti-SLAPP is if it gets struck, it's gone, but leave it in the lawsuit. So we'll still be able to talk about it. We'll still be able to go against the defendants on it. The jury's going to hear about it. They just won't be able to, jury wouldn't be able to use it as an express reason for supporting our claim. To me, that's an in run around the anti-SLAPP, as I would think about it intellectually. I don't have any case that I can look at that says that. To me, if you made it part of your claim and it gets struck, it should be gone from the lawsuit. Now, if you file a lawsuit and you said these things were intentional infliction of emotional distress and none of them were speech, but in your story about how you got here, you included some of these allegations, that's context and background. Hey, they did a letter. They never showed it to anybody, but boy, was it terrible. And it led up to these other things that they did do. That is my claim. To me, that's context and background. But when you say these 4 things happened and 3 of them are speech related and they get knocked out of the lawsuit and only the one's left, and then you say, well, we still should be able to talk about these things because they're context and background, I feel like that's not how that should be interpreted. But I could be wrong on this. And if you're interested in a different viewpoint, in the Manson cases in their last podcast, Andrew Burkhart was asked the same question and came up with a different answer than I did. And she also spoke about, generally speaking, the rules of discovery. And I agree with everything she said from a legal standpoint. And as to her opinion as to what the judge will do with it, it's at least as good as my opinion and probably better. But I am telling you why I feel the way that I feel about it. But it's an educated guess, and it may not be the best educated guess. They put this in their brief, so at least for me that's fun because I'll get to see whether I was right about it or not, at least as far as how this judge views it. So they also have made the case, which was an interesting also point, that when you go down these rabbit holes, that if Gore didn't ask for something to be struck, but Wood did, how can it be struck? How can it be struck out of the lawsuit if only one person asked for it? I don't have the best 100% clear answer on that. My logic still goes to the idea that if it gets struck as protected speech, then it's just gone. It's gone. That's my view of it, especially since the allegation is these 2 people acted together, that if it gets knocked out, it's out. But we'll have to see on that, right? But Manson has put those arguments into his brief, so I think the judge will address those. So I'll be interested to see what she says and maybe learn some things about this, and it'll be less of a guess next time and more of a, well, this is what a court has done before. So again, watch the other lawyers, because now it's in the brief, it may attract more attention from people who can analyze this with more experience in that area than I have. So I guess when I read this stuff yesterday morning before I did the Darrell Brooks stream, I was just scanning through it. I was like, oh, wow, there's a lot of stuff in here that, Manson's team has done a great job, because they write really well. They're very persuasive. They're talented people. They did bring some new evidence and lots of color pictures and things. And again, if you want to see those things, password emails and descriptive information about how somebody was told this salacious information or not, and how that affects, I don't mean to downplay it because it's important, but I don't think it goes to these narrow points of the anti-SLAPP. That's my point. So if you want to know the full context of this, there are other people covering that I've mentioned. And I think it's good to know that if you're interested in the case. What I'm saying is I try and clear that out of my mind unless I can put it to the direct points the judge is being asked to decide in this motion. And if you are putting in new things for this motion that aren't directly on point for the motion, to me that suggests that you got to throw everything at it you can, because maybe you're not able to really clear that hurdle that the judge says. Well, for example, if the judge said, I need to see that this was distributed to somebody else, and you have a declaration from a woman who says, Gore sent me this letter, said it was from the FBI, and then said if I didn't show up and support the allegations against Manson, then the FBI would be checking into me to see if I was part of his conspiracy. Now that would be a slam dunk. You just put that on Exhibit A and you go get an early lunch, because it's all over. But there's nothing that clear here. There's nothing that clear here. And to me, the case isn't clear on either side of it in the evidence that's before the court at this point. They make the case at some point that Gore was telling people we've got hard drives of evidence against Manson. That sounds awesome. I saw it in a documentary too, right? Labeled and everything, and boxes and stuff. What is it? What is so clear against him? Now, if you believe these things against him, and there are some, disturbing things out there about him, and some of them are images and some of them are written, then you're like, dude, it's already out there. Man, there's not hard drives and stuff out there. I mean, I wouldn't need a hard drive to put that information on. I could do that with a little thumb drive, and not a very big one. That's not diminishing it. The point is the hard drives of data real, or is that to create a picture, an image from somebody who's an artist? And I feel like that. And then when lawyers write these briefs and they use words like dragoon, they're artists too, right? They're there to be persuasive. The old theory is if the law is on your side, you pound on the law. And if the facts are on your side, you pound on the facts. And if you don't have either one, you pound on the table. But you got to be pounding something, because your job is to be persuasive. And there's maybe a little of that here, that these guys are making a good case with everything they have. But after I read it the second time, I'm like, there's no great smoking gun here that directly addresses the points that the judge had an issue with. Although they have some cool stuff, some great stuff, they make it look like people were working against him, maybe in an unfair way. He's got that, but does he hit these points that the judge had the concern about? So we'll know soon, because she's going to have the hearing on December 1st to make a decision. The defendants will also file their reply in the next few days, I assume, and we'll be able to look at that, and then we'll know what the judge thinks on this, and then someone's going to appeal it, and in this case, falls off the edge of the earth for quite a length of time. So again, interested in hearing your comments on whether I missed something that directly addresses these points, or just if I missed something altogether. I'm certainly willing to accept it. As I say, I'm like 3 or 4 points removed from being able to figure out how's this thing going to go, because it's a judgment call by a judge. So you got to channel all that. You got to put your mind through all of this stuff and make lots of assumptions, and then we don't even know what the redacted information is. But that's my assessment of it. I saw a lot of pro-Manson people very excited about what was put out there, because it supports the overall case, and I do get that. I'm not arguing that. I just wonder, is it really moving the needle enough for the judge's level of skepticism on these particular points that she put forward in the discovery hearing? And we will see soon. Thanks. Bye.